morning. Please be seated. We are here for oral argument on State of Arizona versus Dimitri, Polanco, Romero. It's our number CR 24-0237. You all are experienced counsel, so you know you have 20 minutes apiece. Keep whatever time you wish for rebuttal. Please begin, Mr. Eichner.
Good morning, Your Honors. David Eichner from the Pima County Public Defender's Office for Dimitri Romero. Martinez and Escalante both represent a sea change in how we look at unpreserved prosecutorial error, cumulative prosecutorial error, but courts are still struggling to apply them. The state agrees that prosecutors' mental state is not relevant, but it continues its failure to appreciate the confluence of Martinez and Escalante through Vargas. Judge Sklar's dissent did not lower the standard of proof for prong 3. Rather, it understood the absurdity of creating a much higher burden just because than prongs 1 and 2, just because more errors exist. Fundamental error is still a high hurdle to meet. Dimitri Romero's trial was fundamentally unfair. It could have affected the verdict. It would have has never been the standard. This court said so in Escalante.
Counsel, I want to pause you on that one, though. Forgive me for jumping in so quick, but when I go back to where that language actually came from in State v. Tucson, the phrasing is, error is held to be reversible error when, from the facts and circumstances of the case, it appears probable that without the error, a different verdict would have been returned. That specifically is looking at prosecutorial error. If we're going to clear all this mess up, why shouldn't we go back and say this has been the standard for prosecutorial error to require reversal since then? Why shouldn't we reinforce that or reinstate it?
Well, since Tucson in 1978 when the court said would have, but in Bracey in 1985 the court said could have.
Right, so why shouldn't we clarify this? If we're going to engage in wiping the chalkboard clean and straighten all this out, why wouldn't we do that?
Well, we should clarify. So is could have or would have a better standard is really what the question is. And this court addressed that in Escalante and went through the state argued for would have as a standard in fundamental error, and this court explained why could have was a better standard.
Well, just to make sure that I am on the same page, I thought Justice Montgomery was asking not about fundamental error, the third step of Escalante, but simply when you're showing prosecutorial error, do you have to show that it would have affected the verdict just in showing the error, even if it's objected to error?
And the reason why, I understand now, and I think the reason why would have is never a good standard is because it creates a sense of inevitability where we can express with absolute certainty that this is the result the jury would have reached. And how could we ever know that with any certainty? Could have is a better standard because it reflects that it's not merely a metaphysical possibility. It's still a high hurdle to meet. But the defense still has to prove the could have standard.
Well, in Martinez, we selected the could have standard for prosecutorial error.
Correct.
Has there been cases since Martinez that have gone back to the would have standard?
I'm not sure which ones, if any, have said would have, but since Martinez, in other ways there have been a back and forth going back to pre-Martinez standards, such as Robinson and even Montoya, which was decided 2 days after the Romero decision in this case had a mental state requirement. So there's a lot of post-Martinez cases that still use pre-Martinez language. So there's a need to clarify these things. So the first thing I would ask for the court to do is clarify it's a could have standard. When breaking down what prosecutorial error is, to break away the possibility of a different result and put that into the harmless error or fundamental errors bracket rather than put it as proof of the error. Just say that the error existed.
I want to ask you a clarifying question. So in one thing to say up front, too, in Vargas, I did not take our court restricting a defendant from being able to bring a fundamental error claim only under prong 3. But if we're talking about prong 3 in particular here, when you mention could have standard, are you saying that, or could have, that that's the nature of the prejudice that needs to be evident then to find that, well, for prong 3, the error or misconduct is so great that we could readily conclude from looking at it that it could have affected the verdict. Done with that. When you say could have standard, is that the context you're referring to it in?
Right, that like once you've already proven that in a prong 3, that it was so pervasive, did not receive a fair trial, could not have received a fair trial, that incorporates the could have. And some other cases, like Montoya, the language bleeds in, but it's not as clear. The state cited Montoya, and I don't think it's as clear there that that's part of the problem. But could have is inherently a discussion of prejudice, whether it be the harmless error standard or the fundamental standard.
Is there any, I mean, the way I kind of looked at all this, I kind of came to the conclusion, at least if we adopt your arguments, that there really isn't a difference when you're talking about prosecutorial error between reviewing objected to error and non-objected to error, fundamental error. Because if you are, at least going under Martinez, you having to make the finding that prosecutorial error occurred, you must find that the misconduct could have affected the jury's verdict, thereby denying defendant a fair trial. And I think in Vargas said, consistent with Escalante, that's always going to be prejudice, so you don't even need to go on to that. So it makes me wonder, am I correct that is there no difference between whether you object or don't object at trial to prosecutorial error?
Well, the problem with the way the court has stated prosecutorial misconduct and prosecutorial error is that because it incorporates prejudice into the definition, it treats harmless error, preserved and unpreserved, the same. That even if there's an objection and it's important, but it doesn't rise to the Hughes level or a habeas level, it would still be reversible because it puts something before the jury they shouldn't consider. But now we've brought into this habeas standard, this fundamental error standard under prong 3 for a preserved issue. So that's why I think that the court should redefine what prosecutorial error is to break up the preserved and the unpreserved. That for cumulative prosecutorial error, which is what we have here, that the standard would remain the same, that you still have to prove denial of a fair trial, which incorporates prejudice. Because if it's not a structural error, then then denial of a fair trial necessarily requires looking at the evidence, looking at prejudice. So that's what we're looking at here. So if Mr. Romero is denied a fair trial, it means...
Aren't you always going to have to show denial of a fair trial for prosecutorial error, be it a single occasion or cumulative?
The nature of prosecutorial error is it's always going to be trial error rather than structural error. So it's always going to be requiring us to look at it in the context of the trial evidence.
But that's not what I asked. Aren't you always going to have to show denial of a fair trial to get relief to prove prosecutorial error?
Yeah, under prong 3 of fundamental error, we'll always have to show denial of fair trial.
Aren't you always going to have I'll try one more time.
Okay.
Forget fundamental error. Just in proving that prosecutorial error occurred, to show that it occurred, aren't you always going to have to show that the error arose to the level of denying the defendant a fair trial?
No.
Isn't that what we said,
Yes.
reading matter of Martinez, to succeed on a claim of prosecutorial misconduct, a defendant, quote, must show that the prosecutor's actions amounted to misconduct and that there is a reasonable likelihood that the misconduct could have affected the jury's verdict, thereby denying defendant a fair trial?
So the reason why I spit out the no and then the yes is because there were two separate questions there. There's the first question, which implies where should we go from here, and the second part of the question was what have we said before. So if we're and the reason why I'm defining it in terms of cumulative prosecutorial error that's unobjected to is because I believe the court's definitions that relate to objected to prosecutorial error should be reviewed under harmlessness standards, which is very different than the pervasiveness and denial of a fair trial. So the Hughes standard was used, I think was a little sloppy in that case because Tom Zawada will meet any standard in that case. So we could state it however we want, and that was going to be misconduct in that case. But there was a lot of objections in that case, and it would, if they had reviewed it under a harmlessness standard, it would have been legally correct to do that, and Hughes still would have won. So if this court is going to clarify the standards, I think it would help to look to differentiating harmlessness from fundamental error as well, even though we're in a fundamental error posture in this case.
So
Oh, go ahead.
I want to follow up on the Chief's question, though, and I get the distinction you're trying to make. If we're looking at a claim of cumulative prosecutorial error brought under either prong 1 or prong 2 of Escalante, you're going to have to identify the error. It's going to have to be error, but then because you also have to establish prejudice, wouldn't you then, in meeting that requirement, have to argue that the defendant was therefore denied a fair trial?
If it's brought under prongs 1 and 2, yes, because prongs 1 and 2 do not incorporate the fair denial of a fair trial specifically, so prejudice has to be proven. That comes right out of Escalante. Vargas was looking at prong 3, and Vargas, at least I read it this way, and the Court of Appeals read it this way, was cumulative prosecutorial error claims get shunted into prong 3.
And that was mistake 1.
So if the court wants to clarify that cumulative prosecutorial error can be prong 1 and 2, then that will clarify matters as well. Regarding the scope of the court's review, the state raised this issue in its response to the OPDS amicus brief. They made a couple of mistakes in their brief. First of all, they said that OPDS raised issues that I didn't, but that's not true. If we look at page 16 of my petition and pages 12 and 13 of my supplemental brief, we talked about the need to explain how the standard for prejudice shouldn't be looking at the language from Fierro, but looking at Escalante. That we don't look at the sufficiency of the evidence. We look at whether it could have affected the verdict. We look at it objectively. And they seem to understand that in their supplemental brief. They didn't, their response to the OPDS amicus brief.
Mr. Eichner, one, kind of going back to where you were talking in response to Justice Montgomery's question, what is the distinction that you would like us to draw between trial error and prosecutorial error?
Trial error is distinguished from structural error, which is distinguished from invited error. All prosecutorial error is one flavor. Trial error is divided into harmless error and fundamental error. And then any errors that can occur in trial that aren't structural and aren't invited by the defense would fall into trial error, which includes prosecutorial error. So I don't see them as a distinction. I see it as a subset.
So if you have, take for example this case, one of the claimed, or I guess adjudicated now, prosecutorial errors with leading questions. So a number of leading questions. That's an evidentiary error as well. It's a trial error. Can be a trial error. Objection, leading. That's a trial error. And we would go along and do that harmless error review as you just discussed. What converts that error, leading questions, to prosecutorial error?
Since before the supplemental briefing was due, the U.S. Supreme Court decided Andrew v. White, and I cited that in my supplemental brief because I think that helps a lot because it shows we've known since the beginning of time that an ordinary evidentiary error isn't necessarily of constitutional magnitude. However, it could become of constitutional magnitude. So in this case, a couple of leading questions isn't going to be of constitutional magnitude. But what happened in this case was extreme. And it wasn't just a couple of leading questions that were inappropriate, like maybe in Robinson, where the court pointed out this was the legal impropriety. It was a little bit of leading questions, but it wasn't that bad. Whereas in this case, pretty much the whole state's case was brought through leading questions. And sometimes it was leading questions from witnesses that didn't even have any personal knowledge, like Detective Simmons being asked about the videos and about the NIBIN, and he had no knowledge of that. All he did was pick up some shell casings.
So what's the constitutional magnitude? What is the constitutional provision that you're talking about when you say that?
The 14th Amendment right to a fair trial.
We're back to fairness, and
right.
I guess you can kind of see where I was leading you back to that point. Why isn't the distinction between trial error and prosecutorial error simply basically trial error that raises to the magnitude of there's a good likelihood that you've deprived the defendant of a fair trial?
That's the way I would define it as well. And then it begs the question, what is a fair trial? And that's why I threw in the I know it when I see it in my brief. And the last time I cited that, I remember, was in my Escalante amicus brief, where what is fundamental error? Sometimes it's hard to define, and it's hard to put our finger on exactly where that goes. But so ultimately what it boils down to is, was the defendant denied a fair trial? And in this case, in the next case, it's going to be a harder line to draw. It's going to be harder to show where it falls. This is an easy case because it was so extreme how much there was. I do want to point out that it wasn't just the leading questions that deny a fair trial, but the improper opinion evidence, which was incorporated with leading to an extent. But in this case, the opinion evidence was foundational. It was the crux of the case because that was the entire case, was identity. And by going so far with not just a one-off with some improper video opinion evidence, that does rise to the level of a constitutional violation, which is all that Martinez and Murray require. Whereas the Court of Appeals in this case, the majority, did incorporate a mental state requirement. So if they had looked at it from the perspective of Martinez and Murray and not from Robinson and Shortman, the Court of Appeals almost certainly would have reasoned this differently because the errors were so extreme. They counted out the video opinion evidence because there wasn't any proof of a mental state.
Counsel, let me ask you one question, too, about the majority referenced, looking at the evidence and the light most favorable to sustaining the jury verdict. Even under prongs 1 and 2, and maybe under 3 in some circumstances, wouldn't we still maybe have occasion to look at other evidence that was admitted to determine whether or not the claimed error could have affected the jury's verdict?
Right.
We're not precluded from looking at the other evidence, is what I'm asking.
The court should definitely look at the evidence. So the Escalante, I think it was paragraph 34, says that we look at the amount of proper evidence because it's pertinent, but it's not controlling. Fierros used the sufficiency standard, and other courts, including Romero, have mistakenly done that now. So the state agrees that we need to reverse course on that and clarify. And I would submit that stating at the outset of a case that we view the evidence most favorable to the result below doesn't serve any value in the first place. With that, I'd like to reserve the rest of my time.
Thank you. Hey, Mr. Bender.
Good morning, Madam Chief Justice. May it please the Court. Josh Bendor for the State. I'd like to start with answering Chief Justice Timmer's question about whether prosecutorial error requires a denial of a fair trial. And we believe the answer is yes. And that's because prosecutorial error is at bottom a due process violation. This Court has talked about it as a denial of a constitutional right, but generally if you had another constitutional violation like a Confrontation Clause violation, we just talk about that. So prosecutorial error is special because it rises to that constitutional level. What is prosecutorial error? And that is fundamentally hard to define, which is often the case when we're talking about due process, and life is complicated, and so describing all the various things in life are complicated. But I think you can maybe break it down into two different things. One is when the error is so pervasive that it permeates the trial. And that's what you had in Hughes. And so it's not just a single instance of a leading question, which would be ordinary evidentiary error, but it's so pervasive that it dominates what's happening in the trial. And then, of course, you have to weigh what else is going on in the trial.
But we do know that you can have a single error.
And then the other thing is if you have a single error, as in Murray, where the single error is so egregious and so important because it raises, an issue like the reasonable doubt standard, then that alone can be prosecutorial error. So I think either it has to be egregious in one of two ways, either through its pervasiveness or the egregiousness of the single thing itself. And I do think it's important for this Court to delimit prosecutorial error, because right now what we have, as one of the decisions below noted, a situation in which defendants raise almost every ordinary trial error as prosecutorial error, because that's the only way in which they can get a cumulative analysis.
So what's wrong with Martinez? I mean, we just addressed this 5 years ago now, and tried to define it. And you heard what I read, at least to Mr. Eichner. Why doesn't that suffice to define it, that there's a reasonable likelihood that the misconduct could have affected the jury's verdict, thereby denying defendant a fair trial? Do you want us to stick with that, or are you saying that that was not enough?
So thank you for that question. Let me sort of break down where we see the could have standard coming into play and then where it doesn't come into play. So I think it's important that there be a difference between the standard when you have preserved and unpreserved claims, right? Fundamental premise of our trial system, criminal and civil, is that errors are supposed to be resolved at the outset, at trial, where they can be fixed rather than resulting in proceedings on appeal. And so the could have standard that Your Honor recited from Martinez and that's found in other cases is appropriate for preserved claims of prosecutorial error. It's also appropriate under Escalante and Vargas, where the defendant has shown prongs 1 or 2 of Escalante, that the error took from him a right essential to his defense or went to the foundation of the case.
What would you show for step 1 of Escalante for unobjected to error, prosecutorial error? What's the first thing you have to do is show there was error. What's
Yes.
the error showing that you would make under your paradigm?
I guess it depends on the facts at issue, so I may not be understanding Your Honor's question. If I may pivot
Okay.
to where I was
Well, let's just go with the leading questions in this case. So there was a number of leading questions, none of which were objected to, and they're saying that taken as a bundle and with other things, opinion and et cetera, that there was cumulative prosecutorial error. Step 1 of Escalante is show that there's an error.
Yes.
What is the showing they need to make under step 1?
So, and let me step aside for a second and then come back to it.
Yeah, you don't want to answer that.
No, I do. But part of what I'm trying to do is be honest with, I think, what this court has been wrestling with, which is that the words that we use to describe the due process problems for fundamental error are very similar to the words that we use to describe the problems for prosecutorial error. And so the challenge is then when you have a situation that combines both of those, how do we do something that's actually making sense in that combining? And that's something that I've wrestled with preparing for today, and I think this court has wrestled with in a lot of cases. So I just wanted to be honest about, I think that's part of what's hard about this, that we're getting at very similar things at bottom there through those two avenues. And what do we do when we combine them? So to answer that question, whether there was error at all would simply be, was the question leading? Whether there was prosecutorial error, I think, as the way the test is stated in Escalante, bleeds into the third prong, being that the error must be so egregious that the defendant could not have possibly received a fair trial, and that the injustice is obvious without further analysis of prejudice. And that's what tells you whether there is prosecutorial error. That is also fundamental error, and that didn't meet the fundamental error standard under prongs 1 or 2 of Escalante because it didn't take a right essential to the defendant's defense and didn't go to the foundation of the case. And I think that last part of that test is fundamentally inconsistent with a could have standard, right? Because it is a situation in which the trial could not have been fair, and the injustice is so obvious that you don't need to analyze prejudice. You can't combine that with a could have standard and make any sense of it. Those things are fundamentally incompatible. So in a case like this, where the prosecutorial error is all unpreserved, it's undisputed, and they haven't argued that it went under prongs 1 or 2 of Escalante. So we're in that third prong of Escalante. Then they need to meet the standard that the error was so egregious that the defendant could not possibly have received a fair trial, and the injustice is obvious without the need to further consider prejudice. And they can't meet that standard here. And they can't meet that standard here because, yes, this was not a perfect trial, and it is not the way we want all trials to go. But at the end of the day, I think if you look at the prosecutor's closing, what you see there is that the heart of the case is not the errors that the defense counsel has focused on. The heart of the case was the fact that the sheriff's deputy tailed Mr. Romero as he fled the scene of the crime, followed him for several miles, arrested him, found a gun on the floorboard of his car, and the gun matched the casings that were found at the relevant place at the scene of the crime where the video and other evidence shows the shooting occurred. And that was plenty strong evidence to convict Mr. Romero.
But weren't there a number of people shooting in the air and stuff to try to disperse the crowd so that I take it that, does the record reflect there were other shell casings around the parking lot?
That is correct. But the record reflects that they were able to figure out which were the relevant shell casings in the shooting, both based on location but also angle. And there is testimony, appropriate testimony from witnesses that hasn't been raised as error. You've got a different angle when you're shooting across than up, and these bullets caused defects in the car that was adjacent to the victim. And that's the location in which the shell casings were found that were tested in the Tucson Police Department lab not, any of this NIBIN stuff, the actual testing, and then the person who tested them testified at trial about the testing she did of these casings that are linked to the place where those things should be found and are linked to the gun found in Mr. Romero's car when he was arrested.
So what role does that additional evidence play? I agree that the strong evidence is in the latter half of the trial presentation. It's the first half that things get really murky. And it seemed like Mr. Eichner was arguing that you look at the bad stuff, where the prosecutor committed errors in isolation. You don't look at the totality of the circumstances, although we've used that phraseology a fair amount. You don't look at the sufficiency of the remaining evidence. Where should we go with that, where you do have some serious errors, whether they're trial or prosecutorial? And I agree with the Chief that the line of demarcation is rather thin and murky there. But where do you go when you do still have a residuum of evidence that is pretty strong?
I think it's an important question. I think you have to look at the residuum of evidence because the question is ultimately, was the defendant's due process rights violated? Did he receive a fair trial? You have to look at the entire trial, and you can't close your eyes to the other evidence that came in. And of course, you shouldn't view it in the light most favorable to sustaining the verdict because we're not here on sufficiency of the evidence, but you look at it objectively. And the key facts that I just recited to the court, none of those are disputed. There's no contrary witness testimony about any of those things. And so I think on an objective view of the facts, frankly, this conviction would merit affirmance even on a lower standard of review. I think on those facts, any reasonable jury would have convicted, but the standard here is higher.
So let me ask you a question on that then. So where there are claims of prosecutorial error, whether under prongs 1, 2, or 3, and then there's either an argument for prejudice or the argument that the prejudice is evident, we take all of that out. If what's left is still sufficient without viewing it in the light most favorable to sustaining a jury verdict, but just on its own objectively, is that then where we would wind up basing our decision, looking at that?
Yes, Your Honor. And that would, that looks different if you're under prongs 1 and 2 versus prong 3. Prongs 1 and 2, the court has used the could have prejudice analysis, not under prong 3. It's different under preserved and unpreserved. But yes, in terms of which evidence you look at, you got to look at the valid evidence that came in terms of affirming or reversing the conviction.
I realized in this case we're looking at under prong 3 for a claim of cumulative prosecutorial error under prong 3 of Escalante, but we talked about this a little bit. I'm wondering what the state's position is on that. In other cases, would it be possible for a defendant to pursue a claim of cumulative prosecutorial error possibly under prongs 1 or 2?
I'll be honest, that's something we wrestled with in interpreting what this court meant in Vargas. I think what Murray says is you can have prosecutorial error that is reversible error, that is singular. And given the way the court has basically said prosecutorial error is one whole thing, it's one due process analysis you're doing, whether it's one instance of that analysis or multiple, then I do think I agree with Justice Montgomery that you could, on the right facts, have prosecutorial error that would go under prongs 1 or 2 of Escalante. And I think that's consistent with Murray.
So when we're doing that balancing of what is left, what evidence that was not obtained through error or misconduct, either way, we're really weighing them against each other, because in the third prong of Escalante, we're looking at whether the error so profoundly distorted the trial, and we're looking at whether there's injustice, right? So if you have this mountain of other evidence, then can we really say there was injustice, even if there was this other error?
Precisely. If you have what's fundamentally a weak case on the good evidence and lots of bad trial stuff leading to bad evidence, then that's a very different due process analysis than if you have a lot of good evidence that properly came in and that supports the conviction.
Mr. Eichner pointed out that the Court of Appeals, in its analysis, at least with respect to the leading questions, applied the standard which he contends is erroneous, which is that there must be evidence of the mental state of the prosecutor in order to qualify as prosecutorial misconduct, and that the state or that the Court of Appeals analyzed at least one of those arguments, that set of evidence regarding the leading questioning, through that lens. And Mr. Eichner contends that that altered the outcome, that if the court had applied the proper standard and recognized that there was no need to prove the mental state of the prosecutor, the Court of Appeals would have reached a different result. What's your response to that?
It's hard to know what the Court of Appeals would have done differently. I think what I'd say is that the case is now in this court, and the question for this court is what's the right standard to put forth, how to apply that standard, whether to affirm or reverse. And we agree that the intent of the prosecutor does not matter in terms of determining whether there's prosecutorial error, because it's ultimately a question of whether the defendant's due process rights were violated, not whether the prosecutor should be subject to discipline, as this court has stated in Martinez and other cases. And so the intent shouldn't come in. And ultimately, I think the issue with the leading questions here is there's just been no sharing by Romero that they made a difference, right? They haven't identified what's the evidence that came in through the leading questions that wouldn't have come in if the prosecutor hadn't led. And that doesn't mean that there wasn't error, but it is relevant to the question of, was the trial so fundamentally unfair that you reverse under prong 3 of Escalante? And I think the answer is no, because they can't really tell you at the end of the day what the jury heard that they weren't supposed to hear.
Isn't that the nature of a leading question, an objectionable leading question? I mean, I was a prosecutor, I was a trial judge. Once you got that objection, usually attorneys are deft enough to get the answer after a leading objection is sustained. And hasn't this court said that objections of the leading nature really don't rise to this kind of, outstanding, reversible nature?
I do think it is the nature of leading questions, and I think it's a reason why there should be few, if any, cases in which repeated leading questions would rise to the level of prosecutorial error, right? It certainly wouldn't be that single instance of egregious conduct under Murray, and so it would have to be sort of this repeated, pervasive, but then you'd still want to show that it matters, right? And leading questions are not the kind of thing that really lend themselves to that kind of thing. Now, look, would it be different if the trial judge continued sustaining objections and the prosecutor continued asking similar leading questions over the trial judge's order in a way that created some sort of chaos in the trial? Maybe that would be a different situation. It's certainly not what we have here.
Counsel, let me ask you a question about options that we have. You mentioned we could either affirm or reverse the Court of Appeals. Given the apparent confusion about some of the standards or some of the discussion about the different prongs of Escalante, what if we come out and say this is how we want these cases to be analyzed, how we want these errors to be reviewed, and we remand for the Court of Appeals to do it to make sure that we've come up with something that they can work with?
You could do that, Your Honor. I think it would be better to simply affirm now. And I think part of the reason is that applying the standard helps show the lower courts how those standards actually work. And so I think this court will give better guidance, and we agree.
We thought we did that in Vargas and in Murray and Robinson and Martinez.
And understood. And look, these are hard problems. I mean, that's why we keep coming here, because due process is hard to define, and it's hard to define two intermingling instances of due process.
Mr. Bender, one thing that I'm left confused by still, listening to your argument, it sounds as if you're saying that, especially if it's objected to error, you could come to the conclusion that prosecutorial error occurred because the defendant was deprived of a fair trial. But if you didn't object, you still deprived of a fair trial, but it didn't profoundly distort, and it wasn't so obvious. But we're okay that, sorry, you got an unfair trial, but that's still not going to be fundamental error. You see that distress that kind of causes me. Can you somehow clean that up for me so that we're not affirming something that we admit is an unfair trial?
Yeah, I do understand that, and I think that is a hard issue. I think the answer I would give is that in deciding sort of the ultimate question of whether there's a fair trial, I do think the decisions of counsel of whether to object or not are relevant to what this court is deciding. And so I just think you can't, as unsatisfying as it may be, I don't think you can disentangle those things. And so if counsel didn't object, then that is relevant to the question of whether this is ultimately a fair trial.
I mean, are there different gradations of an unfair trial?
I mean, you can put it that way, or you can say, is this a trial that violates the due process clause? And in assessing that, part of what you look to is, are these errors preserved or not? Did counsel object or not?
And then we get to deal with ineffective assistance later.
We do, as does our office. And look, I mean, I think in a lot of situations, ultimately the answer will be the same, right? I mean, if it wasn't enough to reverse on fundamental error, it's unlikely to be enough to reverse on ineffective assistance of counsel, right? The analyses are not identical, but they're going to get you pretty similar places in the vast majority of cases. If there are no further questions, I'll ask the court.
No.
Affirm. Thank you.
Thank you, Mr. Bender. Mr. Eichner.
The state's prejudice argument still focuses on a sufficiency argument, still looking only at the evidence that supports the conviction. But Judge Sklar goes through how that evidence, there's contradictory evidence, or at least it shows that it's not entitled to the same weight, such as lots of shell casings, such as the video was not clear. He goes through the whole litany of that. I won't, in the last couple of pages of his opinion. I won't go through every line of it. A fair trial does not guarantee a result. Structural errors are not fair trials, but sometimes the person is guilty of sin and there's no evidence to the contrary, but they still get a reversal. So just because a fair trial or it's an unfair trial doesn't mean we can guarantee somebody's innocence. It just means that the trial that we had isn't a fair trial on guilt or innocence, because a reasonable jury could reach a different result. The problem with leading, and the reason why we have the rule, is it's a form of vouching of the questioning attorney, and in a case like this, it's prosecutorial vouching. So it wasn't just merely a couple questions that then got fixed, but the prosecutor wrapped in the flag then says this is what it is, and is putting the words into the witness's mouth. So this was not. The state says that we're not entitled to a perfect trial, and concedes this was not a perfect trial. But this trial was a farce. It was not even close to a perfect trial.
And I know you don't have much time left. I do want you to answer kind of the questions along the lines we were asking Mr. Bender, and he brought up the excellent point that there should be a distinction if you need to object at trial, and when you don't object to trial, you have a more difficult hurdle on appeal, because those errors could have been cleaned up at trial. So I'm not really hearing the distinction between, once you hit appeal, what is the distinction in the review of prosecutorial error that is objected to and not objected to?
When it's objected to, it doesn't necessarily have to be this 14th Amendment constitutional right to a fair trial. It could just be the jury was given something it shouldn't receive. So the standard it's a harmless error standard. When there's no objection, it's the language from Valdez and then Henderson repeated in Escalante. You want to reserve the whole card to play on appeal. Now you've got to meet the fundamental error standard, and it's much harder to meet. So that's why my trial lawyers are so proud of themselves when they preserve something, and that's why I'm so upset when they don't, because I would have won this appeal a long time ago if these were preserved issues. I'm standing here because this is an unpreserved issue. With regard to what Martinez did, what Martinez clarified for us is the mental state requirement, which apparently it didn't clarify as well, but it doesn't redefine everything else. With regard to Escalante, step one, we still just have to prove the error. Then, because it's fundamental error, now we've got this higher burden. Okay, you didn't just prove an error, you have to prove it's fundamental, you have to prove prejudice under prongs 1 and 2, or denial of a fair trial. And in closing, to answer the question, I think that a remand to consider this, if this court wants to give the Court of Appeals another chance at considering this under the proper standard, that would be acceptable to the defense as well. With that, I rest. Thank you.
Mr. Agnew, thank you, Mr. Bender. Thank both of you for argument today and briefing. We'll take the matter under advisement, issue, and in due course. In the meantime, we will recess to allow the next group to come forward.